Welcome to this presentation regarding Chapter 3 of our textbook. Chapter 3 is the chapter that covers ethics and professional responsibility. Probably more than any other course in our program, we talk about professional responsibility or ethics in the introductory course. So this is where we do the foundational information about professional ethics. In our other courses, we talk about it a little bit, but this is the deep dive. So let's get started. By the way, this is one of the two chapters that I heavily supplement from the textbook. Chapter 3 and the grammar chapter, there's a lot of additional material. You'll find in most of the other chapters in our textbook, my lectures track pretty closely with the content of the textbook, but this is one where I add a lot of extra stuff. Okay, so let's get started. We're going to talk about legal ethics, and one of the things I guess that I was surprised when I attended law school was that when we use the term legal ethics, we're not talking really about doing the noble thing or the kind thing or the good thing necessarily. In fact, there are times that legal ethics will cause you to do things that you kind of wince about and think, oh, I wish I didn't have to do that. That doesn't feel right. That doesn't feel like what I should be doing. So legal ethics aren't the same as your own personal code of ethics. They can be, in many cases they are similar or even identical, but they can be different. And there can be times where you actually feel like it's the wrong thing to do, even though the rules tell you it's the right thing to do. So the takeaway from this is don't feel that you can necessarily trust your inner moral compass to tell you what the ethical answer to these questions might be. The next issue that sometimes comes up with paralegals is, well, why do I need to worry about professional responsibility or ethics? After all, I'm not a member of the bar, so I can't be disbarred for failing to follow the rules. Why do I need to worry about that stuff? Well, you do need to, and we'll talk in more detail about why you need to as we go forward, but it is important that you learn the ethical rules that govern the attorney with whom you work and also indirectly govern you. These are important rules. We're going to talk about them in this course and in subsequent courses, but whenever you feel, actually, let me pause for a second. We're going to introduce you to these concepts, but we're not going to do a very deep dive. Part of the reason for that is that many of these issues are very, very complex, and what we're doing probably more than anything else is preparing you to spot when an issue arises, preparing you to know, hey, wait a second, there's probably an ethical rule about this. Our goal isn't so much to tell you what the answer to that is. The rules can be very complex and really likely require legal research and reflection before you can make a determination about what the absolute correct course of action is. So we are here to figure out the moment in which you can say, there's a professional responsibility issue here, to pause, to talk with the attorney with whom you work at that time, and to figure out an answer. But we're not going to give you all the answers. That would not be realistic. So it's important to know the concepts, to know when an issue arises with respect to professional responsibility. For the most part, paralegals are not governed directly by direct regulation. Now, there are two exceptions. California and Washington State has some direct regulations of paralegals, and there's a few other states that have kind of, sort of, some stuff. Right now, Texas doesn't have anything that would be considered direct regulation. But even though there isn't direct regulation, there is certainly indirect regulation. And let's talk about the ways that paralegals are indirectly regulated. Well, the first way is that paralegals work for attorneys, and attorneys are directly regulated. And so attorneys have to follow the ethical rules. And an attorney is responsible for everything that happens in his or her law office. So if a paralegal is working for an attorney and the paralegal violates an ethical rule, then the attorney is responsible for that violation, and the attorney can be sanctioned, including being disbarred. even if that is not what results, the attorney, if he or she learns that there's been an ethical lapse, is very likely to be very concerned about that and very likely won't continue the employment of a paralegal who knowingly engages in unethical behavior. And again, when I use the term unethical, I don't mean personal ethics, I mean professional ethics. So paralegals are indirectly regulated because their supervisors, the attorneys, are directly regulated. Another way that paralegals are indirectly regulated, and I guess you could say this is actually direct regulation, but there are laws relating to the unauthorized practice of law. That's what UPL stands for, the unauthorized practice of law. And this is, of course, the idea is similar to any other profession. There are barriers to entering any profession. That's one of the definitional characteristics of a profession. And individuals who pretend to be a member of the profession who aren't can be subject oftentimes to criminal or other sanctions. And in the case of the unauthorized practice of law, that would be a criminal sanction. So if a paralegal acts as if he or she is a licensed attorney, that can be a felony, and there can be prison time associated with that. So we'll talk more detail about what qualifies as the unauthorized practice of law and how to avoid that behavior. And finally, there are guidelines. And of course, in this context, we're using the word guidelines to mean kind of recommended or best practices. The American Bar Association, the ABA, is a voluntary organization. Paralegals can be members, but most attorneys aren't members, and certainly the vast majority of paralegals choose not to be members of the American Bar Association. But there are other organizations such as NALA, among others, and also state bar associations with paralegal chapters, including the Texas State Bar. All of these are organizations that give guidance to paralegals and attorneys who work with paralegals about what are the best practices. Certainly, if you are a member of one of these organizations, you are bound by the rules, and if you violate them, presumably you can be thrown out of that organization. But even if you choose not to be a member of these organizations, they're good best practices, good guiding thoughts for you to have as you practice in your career. Let's go forward. Okay. So let's talk about how attorneys are regulated. This is an important topic for us to know about because it helps make it clearer why paralegals can't give legal advice. And so let's talk about that process. First of all, let's talk a little bit about why we have regulation of attorneys to begin with. The idea is that it benefits the public. But let's do a comparison. Let's talk about regulations of doctors for a second, because I think that's even a little bit more intuitive. Let's imagine that there was no regulation of doctors. Let's imagine that anyone who wanted to call himself a doctor just could. And let's say I decided I wanted to be Dr. Groover, and so I put up a business and bought, some equipment and hired a receptionist and advertised to the world that I am Dr. Groover. And I start accepting patients, and I start diagnosing conditions and prescribing medication and other tasks that doctors routinely perform. Maybe I perform some surgeries. Well, the people who come to see me, in most cases, aren't going to be medical professionals. They are going to be seeking out medical advice, and they obviously want to get the best medical advice that they can get. And they are trusting me that I have the answers to their questions about their health. But I really don't. I'm not any more knowledgeable about medicine than they are. Or maybe I'm a little bit, but not very much. And so therefore, when I suggest that they take this medication and they take it, but really they had a different disease, and because it wasn't treated appropriately, they die, well, that's kind of bad for them. And so we can see why we want doctors to be regulated. We want, when a layperson goes to see a doctor, that layperson can trust that this person actually has very significant training in the medical field. Otherwise, people are going to get poor medical advice, and they won't know which doctors are the ones that are real, are good, know what they're doing, and the doctors that aren't. The urgency is a little bit less in the legal profession, but not much, because after all, the decisions that relate to the law can have dramatic impacts upon people's lives, whether they are incarcerated or not, even whether they are subject to the death penalty or not, whether they are going to, after they're injured, whether they're going to get a significant jury award in a particular case that will allow them to live comfortably, or whether they're not going to, whether they're eligible to get a divorce or not, whether they're eligible to have custody of their children or not, how the proceeds of an estate, maybe when their parents die, who's going to get that money. All these things are really important issues in people's lives. They can affect dramatically the quality of those individuals' lives. And so if I go to someone and he or she represents himself or herself as an attorney, and that person gives me legal advice and I follow it, but it ends up that that person had no idea what they were talking about, and I follow that advice, I may well, that poor advice may cost me millions of dollars. And so it's important that when we go to see somebody who calls himself or herself an attorney, that that person really knows what he or she is talking about. And the way that we do that in our system is, I think, a fairly sensible way. We have educational requirements. Typically, an attorney has to go to college, a 4-year school, and get some kind of degree. There's no particular degree or no particular courses that the attorney has to take. At the end of the 4-year degree, then he or she can choose to enroll in law school. Law school is a 3-year program, and at the end of those 3 years, the law student graduates, and if he or she has gone to an ABA accredited law school, he or she is eligible to sit for the bar in the state of Texas. How does one qualify to sit for the bar? Well, that person has to have graduated from an ABA accredited law school. The person also has to pass a criminal background check. And then that person has to take 3 tests. The first test is called the MPRE, the Multi-State Professional Responsibility Examination. It is, as far as I know, in all 50 states, but if it's not in all 50 states, it's in a lot of states. It's in the vast majority of states, and it's certainly the test for Texas. That's actually a relatively easy test, and most law students take it while they're still in law school, but you don't have to. You can take it after you've completed law school. Then there is a day, typically it's twice a year, where individuals sit for the bar. The bar is the same in all or virtually all states. The first day of the bar typically is called the multi-state day. And this is the day where former law students who are sitting for the bar will take a Scantron-based multiple choice test. When I took it, it was 200 questions. I'm not sure if it's that long or not now, but it was 200 questions, and you took it over 6 hours. And those were questions about the common law, torts, contracts, things like that. Laws that are, for the most part, very, very similar across state lines. The multi-state is not in every single jurisdiction. I know it's not in Louisiana, but it's in the vast, vast majority of jurisdictions. So the next part of the test, in Texas we have 2 more days of the test. The next part is an essay test where you write several different essay questions relating to Texas-specific law questions. In this case, there may be some Texas common law questions, but most of it is going to be statutory, things that are unique to Texas. And then the final day of the Texas bar is a kind of a short answer, fill-in-the-blank kind of test where you answer questions about particular Texas rules of civil and criminal procedure. Things like, how many days do you have to file this document, or what are the procedures for filing that document? Those types of things. So if I have been successful by graduating from an ABA-approved law school, if I have passed the MPRE, the ethics test, and if I've passed the Texas State Bar, and I've passed my criminal background check, and of course if I've paid my money, I can join the Texas Bar. And that's a very similar path for other state bars. There are a very few states that don't require attending an ABA accredited law school. There may even be a state out there that still allows people to sit for the bar after they've apprenticed with an attorney. Certainly, once upon a time, that was a very common way to become an attorney. You were an apprentice for several years to a practicing attorney, and you kind of learn by doing, almost like being a paralegal. Um, Even up until the 40s and 50s, there were some states that had that. I'm not sure if there are any states today that have it. There's certainly much, much fewer. But there are a few states that do have the option of going to a non-ABA accredited law school. The ABA, the American Bar Association, accredits law schools. It tells state bars these are law schools that have very rigorous and well-designed academic program to train people to become attorneys. There are, though, a handful of schools out there that are not ABA accredited. You may think, well, why would anyone go to a non-ABA accredited law school when they can't sit for the bar? Well, there's a few reasons for that. One category is that there are a few locations that allow individuals to sit for the bar even if they haven't gone to an ABA accredited law school. The most famous example certainly is the state of California. You do not have to attend an ABA accredited law school to sit for the bar in that state. There are also other states, I happen to know that Alabama falls into this category, but there are probably others that will allow you to attend a particular non-ABA accredited law school, oftentimes one within the borders of its state. They carve out a one-time exception to that particular law school for their bar examination eligibility. So that can be a reason that the student can still sit for the bar in the state that he or she wishes to, even though he or she is attending a non-ABA accredited law school. Sometimes people attend a non-ABA accredited law school because their goal is not to practice law, but to do something else with their legal training, perhaps to become a paralegal or something like that. A third factor can be that, or I guess a third category, and this is perhaps not, this is somewhat of a different category than we talked about before. But when a law school first opens, it can't be ABA accredited because it has to have some track record, it has to have had classes before it can acquire its approval. I'm sorry, not approval, it's accreditation. So you might want to enroll in a law school that's just opening up, and maybe in the first year or two it isn't yet ABA accredited, but you expect that it will be ABA accredited in the near future. And so you're taking a little bit of a risk, but it's probably a pretty safe risk if it's a school associated with a major university, and or a major, typically a major university. There's a few exceptions to that. So that is another reason that you might go to a non-ABA accredited law school. You may think to yourself, well, why do some law schools choose not to be ABA accredited? Well, I guess the first thing I would say is they probably don't choose to be non-ABA accredited. Well, actually, that's not entirely true. Some do choose that. But most would, all of them actually would like to be ABA accredited, but they, because of circumstances, are not able to do that. One reason can be that their students are perhaps needy, that they lack the funds to pay as much in tuition as a typical law school costs. ABA accreditation is a good process in that it ensures that students who attend really get a robust legal education. But all the requirements that they put on the law schools tend to make law school very, very expensive. And so some law schools say, wait a second, we want to make law school available to people who don't have the sufficient funds or aren't able or willing to assume that much debt. And so we are going to cut some corners and still provide what we think is a good and good quality legal education, but at a more affordable price. Another ABA requirement that sometimes causes problems is that the ABA does not allow online curriculum. I don't think they allow it at all in law schools, and if they allow some, it's not very much at all. And of course, many times students, especially students who don't live near a law school, find that obviously very difficult. And so there are some online programs that would never be eligible, at least not with the current thinking, would not be eligible for ABA approval. So those are some aspects of the educational and licensing requirements. In addition, there are ethical requirements. Let me share with you a story of somebody with whom I went to law school. I attended law school with this person. I'll call this person Sally. I barely knew Sally at all. I don't even know that I would have recognized her, but I certainly knew who she was, I guess you could say. And at the end of our first year, most of us went to the state that we had been living prior to law school and went to practice at a law firm for some period of time. But Sally, I think she was from Rhode Island, and she went to Rhode Island, but Rhode Island doesn't have the most robust legal industry. And so she wasn't able to find a legal position. I believe that she was married, maybe even with children. And so she went home and she decided that she was going to wait tables for the summer. And that's what she did. Well, over the course of that summer, she underserved a minor, or she served a minor, I guess. And that resulted in a prosecution. And so as a result of that prosecution, she now has a criminal record. I don't know any of the specifics. I don't know who she served and why she served and what the circumstances were. But as a result of that, she lost her ability to sit for the bar because she now had this criminal record. And so she did not return to law school. She had 1 year of law school, and she had the debt associated with 1 year of law school, but she was, at least not in the short term, going to be eligible to sit for the bar. So she could have continued in law school, but it would have been kind of pointless at that time. So criminal behavior on the part of a student, even sometimes non-criminal behavior, can result in a person not being eligible to sit for the bar, or not to be eligible to be continuing their bar membership. Now, certainly I don't want to blow this out of proportion to anyone listening who has a criminal situation. It doesn't follow that every single crime that may be on your record makes it impossible for you to sit for the bar. Certainly minor offenses like parking tickets, speeding tickets, assuming that there weren't injuries and that kind of thing, and there aren't an excessive number, aren't going to interfere with your ability to sit for the bar at all. We're talking typically about crimes of dishonesty, crimes of that nature, of violent crimes, things like that. So if you are thinking about going to law school and you have something on your record, it is a good idea to look into it more so you don't end up spending all that money and being disappointed that you're not able to ultimately practice law. The ethical obligations aren't simply that you not have committed a crime, though. They tell you what you can't do, don't commit crimes, but it also tells you proactive things that you have to do. For example, you have to charge reasonable rates. You can't, let's say you're the only attorney in town, you can't charge 4 times what people are charging in a town of a similar size 100 miles away. That would be an ethical violation. We'll talk more about the particular rules, but just keep in mind that an attorney has to follow them, and if he or she doesn't, then he or she can lose his or her license. So how does an attorney lose his or her license? What is the process that we follow for an attorney to have that outcome? Well, the first thing to remember is that attorneys are self-regulated, but this is kind of a misleading term. When I hear the word self-regulated, I think that I'm regulating myself, and I don't mean that. I don't mean that I guess in some sense, obviously we're all grown-ups, we all know how to regulate ourselves, but in this case, I don't mean that an individual attorney named Bob regulates himself. Well, obviously, if that were the standard, then Bob would never turn himself in, and so there would be no limitations on Bob's behavior. If he's unethical, he'll regulate himself in an unethical way. Now, when I say that attorneys self-regulate, what I mean is the group of attorneys in a state regulate each other. So when Bob makes a mistake, it's not an ethical lapse. It's not he who regulates himself. It's his colleagues. It's the other attorneys in the state who say, Bob, you shouldn't have done that. This is the penalty for doing that. So now some people disagree with self-regulation. Some people say, well, that's kind of like the fox guarding the hen house. We shouldn't have people in that industry regulating other people in that industry. It's a little bit too clubby, which of course is a valid concern. But many professions, I think it's pretty much of a hallmark of professions that there is a self-regulation. Doctors regulate themselves, engineers regulate themselves. So that's a pretty common approach. The primary mechanism that we have in jurisdictions is the state bar associations. In order to practice law in a particular state, virtually every attorney has to be a member of his or her state bar association. That's different than the American Bar Association, which is a national organization that is voluntary. The vast majority of attorneys are not members of the American Bar Association, but virtually all practicing attorneys are members of their state bar association. I mean, there are a few situations where you don't have to be a member of the State Bar Association. You can still practice in the state, but those are very, very rare circumstances. Okay, so the State Bar Association exists, and it is a source of regulation. And it really functions pretty much like a club. A president is elected every year by the members. The rules of the club are voted on by the members. When rule changes are made, they're voted on. You have to pay your annual dues or your membership lapses. You have to meet the requirements of the club. For example, continuing legal education requirements. In the state of Texas, you have to take 15 hours a year, and 3 of those 15 have to be in the area of ethics, for example. And if a member hasn't satisfied those requirements, then his membership lapses. Kind of like if you're a member of, say, the National Honor Society in high school and your GPA drops, well, you'll lose your membership. Similar idea with the Bar Association. It's a little bit different, though, than your typical club in that even though it is a private club, it can control what people do. For example, most private clubs, if I choose not to join it, that club can't tell me what to do. If I choose not to join the National Honor Society in my high school, that National Honor Society can't tell me anything about what I need to do or not need to do. But the Bar Association can tell people. The Bar Association can say to somebody who isn't a member but is calling himself or herself an attorney, can say, no, you can't do that. And the state will agree, and the state will say, hey, because you haven't joined this club, you don't get to practice law. So it is a quasi-public organization as well. And as a result, there is oversight. And we have oversight really from lots of different sources. The state Supreme Court, in Texas, this is going to be the Texas Supreme Court. Oversees the Bar Association. Obviously, the justices on the Texas Supreme Court are all members of the Bar Association. They are all attorneys. But when they are acting in their role as the justices of the Texas Supreme Court, they are acting in their role as judges more than they are acting in their role as attorneys. And so they are involved in establishing rules about the Bar Association and enforcing those rules. A little pause here. We have, this is called this category, which is from the textbook, says state Supreme Courts. And of course, Texas does have the Texas Supreme Court. Texas also has another co-equal Supreme Court, and that is the Texas Court of Criminal Appeals. It handles criminal matters, whereas the Texas Supreme Court handles civil matters. However, only the Texas Supreme Court is involved in managing the Bar Association. The justices on the Texas Court of Criminal Appeals are members of the Texas Bar Association, so they're certainly involved in their role as members in monitoring it, but they do not have this kind of leadership role with respect to the Supreme Court. So that's a little thing to point out. Also, state legislatures regulate the practice of law. For example, in Texas, all attorneys have to pay an attorney occupancy tax in addition to our bar membership. They can also adopt more, if, for example, if they're not satisfied with what the Texas Bar Association has done in the areas of ethics, they can implement new rules and regulate it just as they can regulate any other industry. Many of the legislators in the Texas legislature are attorneys, many are not. So many are members of the Bar Association due to the fact that they are attorneys. But when they are acting as legislators, they are not, they're overseeing the Bar Association as opposed to being a member of the Bar Association. Then we also have the U.S. Supreme Court. The U.S. Supreme Court primarily looks at constitutional issues, U.S. constitutional issues with respect to the practice of law. Let me give you an example of how the U.S. Supreme Court has regulated attorneys or has been involved in the regulation of attorneys. When I was growing up in the 70s, attorneys didn't advertise, really, at all. There just was basically no, at least that the average person saw. There were no ads at 2 a.m. in the morning. There were no ads on telephone books or things along those lines. There's no learning websites for sure. That was considered sleazy. People who even kind of suggested doing that were considered ambulance chasers. But, and I'm not taking a position one way or the other whether it's a good thing or bad thing, but it is true that there were people who had significant injuries or had significant issues come up in their lives who didn't have connections to the legal industry. And they didn't really know how to maneuver within the legal industry. They didn't know who to call or how to access those types of services. Sometimes perhaps they didn't speak English, and so they had that additional barrier to overcome. And so sometimes people who perhaps had a good legal claim didn't really know what to do, and so didn't get the representation that might have benefited them and their families. So there's an argument that advertising helps more people be able to access legal services. Well, as I said before, as far as I know, virtually every state, if not every state, prohibit any kind of attorney advertising. But some attorneys, some of them, we call them plaintiffs' attorneys, attorneys who represent people who have experienced some kind of injury and want to sue about it, be it a car accident case or something along those lines. They felt, well, we can't find our clients. We can't reach out and communicate to them, and they have to figure out where we are, and many of them don't know how to do that. And so maybe we never get that connection, and so they never get the representation that would have helped them. Well, the matter went up to the U.S. Supreme Court, and the U.S. Supreme Court decided that it was a First Amendment issue, that there is businesses do have a First Amendment right to commercial speech, and advertising is a type of commercial speech. And so what it ruled was that the state bar associations, including the Texas Bar Association, could not absolutely prohibit all advertising by attorneys. Now, the U.S. Supreme Court did acknowledge that there was a need to have regulation so that attorneys would not mislead or misrepresent things to potential clients, because obviously in many cases the clients are not very legally sophisticated. So now advertising is permitted, but it is pretty significantly regulated. And so that's an example of how the United States Supreme Court has affected how attorneys regulate, or how attorneys are regulated. I'm going to go to the next slide now. When we do this in class, we talk about these a little bit more detail. So we've kind of already covered this top one. This answer to this one is true. They're regulated by other attorneys, and these attorneys are members of the Bar Association, or justices on the Texas Supreme Court, or even justices on the U.S. Supreme Court. But the word primarily is important here because, again, there is some regulation by people who aren't attorneys, for example, those legislators. Let's talk about licensing requirements. I kind of already covered this. Again, they vary state by state. If I'm a member of the Texas Bar Association, I'm just eligible to practice in Texas. Now, there's a little bit of a leeway here in this point. Because we are a federal country, we have both state systems and federal systems. There is no true federal bar association. But when I'm a member, let's say I choose to be a member of the Texas Bar Association, and let's say I choose to become a litigator. Well, I'm probably going to want to be a member of my local federal court as well. So let's say that I let's say I'm practicing in Houston, and so I want to be a member of the Southern District of Texas Federal Bar, so I can appear in those courts. Even though that court is within the borders of the state of Texas, it is a federal court, so being a member of the State Bar of Texas does not make me a member of the Southern District of Texas or any of the other federal districts in Texas. I have to apply for membership. Joining the federal bar, though, is really easy. It's a small expense. You have to demonstrate that you are a member of some state bar association. Doesn't have to be Texas. It could be any state bar. And many times you have to attend a CLE, a continuing legal education seminar, oftentimes about the local rules in that particular court. So I could join, say, the Southern District of Texas, and in fact, it's very common for attorneys to be a member of only one state bar, but to be a member of many federal bars, such as Southern District of Texas, which would be Houston, the Northern District of Texas, which would be Dallas, the Eastern District of Texas, which would be Collin County. You can have multiples of those, and again, because I am a member of the Texas State Bar, I could join the Wyoming Federal Court if I wanted to. So in that respect, the licensing requirements vary by state. Obviously, the contents of that state individualized part will vary. There is no national bar test. It is true that the MPRE and the multi-state are national tests, but the actual score you have to have on it is established by your particular state, and states don't have to require those tests. So what do you need? We already talked about the bachelor's degree, the ABA accredited law school, passing the state bar, and passing the background check. By the way, the background check is very, very involved. You got to be fingerprinted. They ask you loads and loads and loads of questions. Let's talk about the ethical rules that you have to follow. The Model Code of Professional Responsibility was the first kind of attempt at doing this by the American Bar Association, and it was passed a pretty long time ago in 1969. It's still in effect in some states, such as New York, but most states have adopted the latest version of the ABA rules. Oh, well, I guess we have questions. Once admitted to practice in a state, an attorney may practice at any state in the United States. That's false. If I'm admitted to practice in Texas, Texas is the only state I can practice in. Now, I can go to another state and join the federal bar and practice in federal court in those states, but I can't practice in the state bar or state courts in those states. In order to sit for a state's bar exam, an individual must have a bachelor's degree, a law degree, and pass a background check. That's true. This is the second attempt by the ABA, the Model Rules of Professional Conduct, and this is more recent, 1983. Most states have adopted this, including Texas, although Texas's name for it is the Disciplinary Rules of Professional Conduct. So you can see we've taken away the word model and replaced it with the word disciplinary. Now, the rules from the model rules Texas has adopted, but it doesn't mean that Texas hasn't tweaked them. Let me pause for a second and talk about what model rules are. Model rules are ideas that some private organization have come up with. In this case, it was the American Bar Association, but it could be really any organization. And they say, you know what would be the ideal set of rules? What is our recommendation for what we ought to have as a rule in this particular area? And so these people get together and they come up with the model, the perfect model in their mind. And then once they finish it, while they've accomplished the first part of their task, really they haven't done anything because it's not self-implementing. They've developed this document, but it's not enforced anywhere. It's just kind of an interesting document. It doesn't have any effect. So then they have to market it to all of the different states. So literally they go state to state and talk to people in Indiana and Wyoming and California and Florida and Massachusetts and Texas. And in those jurisdictions, some states will say, yes, we love this. We're going to sign up and do this right now. In other states, they'll say, no, we hate this. We're going to stick with our own rules, or we're going to stick with, here we go. We're going to stick with this earlier version, the Model Code of Professional Responsibility. And again, the ABA can't force any state to adopt the rule, or states can, and this is the most common thing, is the state can adopt it, but then tweak it. Say, well, we like 95% of this. We think this is good, but there's a couple of provisions we don't love, and so we're going to tweak it. So even in states that have adopted the model rules of professional conduct, they are not going to be word for word, semicolon by semicolon, exactly 100% identical. So let's talk about the sanctions that the Bar Association can levy against an attorney who violates one or more of these rules. Well, the first is reprimand. A reprimand is just what you think it is. It's when when your mom fussed at you when you were a kid. It's a hand slapping. It's getting a stern talking to type of thing. There are two types in Texas. There's a private and a public reprimand. In the private reprimand, you're told you're reprimanded, but you're not told in public. It is published in the Texas Bar Journal, but it doesn't say your name. And so the only people who can tell that you've been reprimanded are the people you choose to tell, you the reprimanded person, the private reprimand. And then there's also a public reprimand where your name is actually mentioned in the reprimand. And so people who read the Texas Bar Journal, I'm going to go and flip over to the Texas Bar Journal so we can look at that. I'm going to, just to show you where it is, it's in the texasbar.com. By the way, anyone can access this. This is available to attorneys and non-attorneys. And then we're going to go to news and publications. We'll go down here to the Texas Bar Journal. I'm going to go to the digital edition. I'm going to flip to the end. And go back, because this typically is near the end of the publication. These are people who've passed away. Here we go. I'm going to go to the beginning of this section. Okay, so read the disciplinary actions. By the way, this is kind of like the gossip page for attorneys. When attorneys get the Texas Bar Journal, this is what they flip to first. So you can see these individuals have been disbarred. So we have Mr. Nolan has been disbarred. I mean, you get information about who he is, what his bar number is, where he was practicing, and what he did. And then we see that Mr. Rogers was also disbarred. Let's just see what Mr. Nolan did. He had two separate violations. He neglected the legal matters entrusted to him, failed to promptly comply with reasonable requests for information from his clients, failed to refund unearned fees, and failed to respond to the grievances filed against him. And then we have Mr. Rogers. Mr. Rogers neglected a client matter, failed to carry out the obligations owed to his clients, failed to promptly respond to reasonable requests for information, failed to keep a client reasonably informed, and failed to return a client file. So these are the disbarments. Then we also have resignations. So these are individuals who resigned from the bar. Most likely they resigned because they realized they were going to be disbarred. So we have Ms. Clemens here, Mr. Coleman, Mr. Guerrero, Mr. Loya, Mr. Pascal. And then we have suspensions. Let me flip back here. We can go over our list here. You can see that we've talked about, actually we haven't gone, let me flip to the reprimands first, since that's the one we were talking about. So we're going to go to the next page. Public reprimand. Here's the private reprimands. These are the ones in which you don't get to hear the name of the person. So it says, listed here is a breakdown of violations for 7 attorneys with a number of parentheses indicating the frequency of the violation. So for example, for this first rule, we had 2. This one we had 4, 1, 3, 1, and 1. Then we have the public reprimands. Now these individuals, their law license is not being affected. They can continue to practice law. So Mr. Veenstra and Mr. Nguyen can continue practicing law, but they have been publicly kind of, I guess you could say, embarrassed. And so here we have, let's find out what Mr. Veenstra did. Mr. Veenstra accepted an agreed judgment of public reprimand. The Honorable Scott J. Becker, presiding by special assignment to the 295th Civil District Court of Harris County, found that Veenstra failed to adequately communicate and keep the complainant, which is probably his client, reasonably informed about the status of the matter. Veenstra violated this rule. He was ordered to pay $750 in client's fees and direct expenses. And then Mr. Nguyen received an agreed order of public reprimand. An evidentiary panel of the grievance board found that the complainant hired Nguyen to represent him in a post-conviction habeas corpus matter. So this is a criminal defendant who had been convicted, and he had his final conviction, and now he is seeking a collateral attack on his conviction. The fee paid was $20,000, and representing the complainant when neglected the legal matter entrusted to him, failed to keep the complainant reasonably informed about the status of the matter, failed to timely furnish the Office of the Chief Disciplinary Counsel a response or other information as required by the Texas Rules of Disciplinary Procedure, and did not in good faith timely assert a privileged or other legal defense for his failure to do so. So this is an example of a public reprimand. Most attorneys never have any kind of disciplinary action. Many times, though, when an attorney has one, it'll be this private or public reprimand as kind of the first step. Obviously, if it's serious enough, you can get disbarred as the first activity. But many times there's kind of some warning or progressive discipline, you could say. Suspension is when the bar membership is suspended for a period of time. Let's go back to the document. Let's look at some of the suspensions. Suspensions can be for 6 months, 2 years. I've seen both. Many times they're probated, meaning here, for example, Mr. Alford received a 5-year partially probated suspension effective at this date, with the first 18 months actively suspended and the remaining remaining probated. So he's actually not going to be allowed to practice for 18 months, but after the 18 months, he will be able to practice because that part's been probated, unless, of course, he makes another misstep. And we can see, let's look at Miss Anasi. Hers, again, was partially probated. And then Mr. Ferguson received a 12-month probated suspension, meaning his won't be suspended. He won't be suspended at all, assuming he doesn't have any other violations. You can imagine that suspension is a more severe sanction than a reprimand, because you can't practice law during that time. So any clients that you currently have, you have to refer to other attorneys. The odds of those clients coming back are pretty small, because who wants to return to an attorney whose bar license has been suspended? So it's pretty devastating to practice, obviously. And then, of course, we have the disbarment, which means you aren't able to practice at all. Let's look for a second at, let's see, let's go back to well, actually, so I'm going to open up a new window. I'm going to go to the texasbar.com, and now we're going to do find a lawyer. We're going to look up these individuals' names. It's possible they haven't been updated yet, but I would hope that they would be. So let's look up Mr. Nolan's name. All attorneys who are admitted to practice in Texas are going to have their names in here. So I'm going to look under Mr. Nolan, and let me find his first name. His first name is James Andrew. And you can see here he has a red box by his name, which means he is not eligible to practice law anymore. And so let's click on his profile. And it says not eligible to practice in Texas. Click for detail. disbarred. So you can see, and this is a good idea if you're seeking legal services, to make sure that you know, the person that with whom you are perhaps considering hiring doesn't have any disciplinary actions. Let's look at the public records. Let's look at Mr. Wynn. I think it was William Wynn. What was it? William R. Wynn. This was, oh, we have another page here. That's the problem. Here we go. You can see he's still eligible to practice law. He still has the green go light. But if we look at his profile, we're going to see at the bottom, he does have a public reprimand listed here. So that's how you can check. It's also a good idea, even when you're not seeking legal services, but perhaps you are thinking about working for a particular attorney. It's a good idea to check to see what the disciplinary background of that person might be. So that's what the bar can do. The bar is a civil organization. It's a club. It can throw people out, but it can't throw people in jail. So another thing that can happen, and by the way, how does the bar find out about these activities? In the vast majority of cases, it is referred by the client. Now, certainly there can be cases in which opposing counsel refers an attorney to the Bar Association, or a judge refers the matter to the Bar Association. So there's a variety of ways it can happen, but the most common way is because of the client complaint. But the client really doesn't benefit directly by filing a complaint against an attorney through the state bar, because there's no money in it for the client. The client doesn't get, even if there are some fees aside to it, the client doesn't get that money from the state bar. The client may get some satisfaction out of knowing the person who wronged him has been punished. He may be pleased to know that future clients may be more protected, but it's not a direct help to him. It is an indirect help, though, because if you have persuaded the state bar to discipline its member because of what that member did to you, you can imagine it's much more easy for you to establish in court that you have been the victim of a professional malpractice. And of course, when you file your lawsuit alleging professional malpractice, you can get money out of that. So that's how it can be beneficial to the client. So whether the attorney gets some kind of disciplinary action by the state bar, of course, that person can still be sued for malpractice. And of course, huge damages can result from that. And finally, there is the possibility of criminal liability, fraud, embezzlement, unauthorized practice of law, all the other types of criminal behavior that can exist in a business and a white-collar environment can happen here. Now, the paralegal can't be disbarred, but the paralegal is subject to these two. The paralegal can be sued for negligence, and paralegal certainly can be sued for criminal liability. So only this top one is an area that the paralegal cannot be directly affected. But of course, he or she can be indirectly affected because, of course, if your attorney is disbarred, well, you're pretty much out of a job. So, and your reputation is likely to be tarnished by having associated with this disbarred attorney. So let's go some true and false. A bar association can disbar an attorney. True. A bar association can jail an attorney. False. Now, of course, if the bar association decides that the attorney's conduct was so egregious that it should be referred to the district attorney for criminal prosecution, The Bar Association can and will refer it to the district attorney for that purpose, but the Bar Association itself cannot jail an attorney. A Bar Association, though, can suspend the license of an attorney. A client's only option against a negligent attorney is to the Bar Association. False. He or she, the client, can file a malpractice claim against the negligent attorney, and if there's criminal matters, can file a criminal complaint against the negligent attorney. The Texas disciplinary rules for attorneys is called the Disciplinary Rules of Professional Responsibility. Well, let's go back and check. It's Disciplinary Rules of Professional Conduct. So this word is wrong. So that's false. Let's look at the equivalent paralegal ethical codes. There are two. We're really just going to focus on NALAs in this particular chapter. But the NFPA also has a code of ethics. Of course, they've revised it over time. NALA is the one we're going to focus on. They have 10 canons, and we'll go over in very briefly all of those 10 canons. And similarly, they developed in the 1970s and they revised it over time. Obviously, because these are private clubs, these are organizations you choose to join, you don't have to be a member to be a paralegal, you can't be required to comply with these rules. Now, of course, if you are a member of NALA or the NFPA and you don't follow the rules, then NALA and the NFPA can kick you out of their organization, just like the Bar Association can kick an attorney out of the bar. But if the attorney is kicked out of, the paralegal is kicked out of one of these organizations, he or she can still practice as a paralegal. True or false? Paralegals are subject to the disciplinary procedures of their state bars. False. They're not a member, so they're not subject. Paralegals are required to follow the ethical rules of the Paralegal Association. This is a little bit, you could kind of answer this either way. I would not write a test question like this. I'm going to say false, because it depends on what you mean by required. If you want to remain a member of the organization, you're required, but if you don't want to maintain your membership, you can still work as a paralegal, even if you aren't. So I would say that not the best worded question, but probably the better answer is false. My mouse does not, here we go. Here are the NFPA's rules. Again, I'm showing them to you just so you can see them. We're really not going to go through these in this particular lecture. Many organizations have guidelines for how to use paralegals. One thing to keep in mind is that bar associations and attorneys both encourage the use of paralegals by attorneys. Let me show you something. Go over here to our, I'm going to go to content. And I'm going to go down to paralegal orientation module. Oh, shucks, I don't have it here. Okay, I may have to go to a different course to get this. To see if it's here. Here we go. So this is the, when you're in here, it will be, you won't see this top one, so it'll be the second one down. So the Chapter 3 Addendum, Paralegal Definition and Standards, State Bar of Texas. This is how the State Bar of Texas defines a paralegal and explains how they ought to be used. And this is the definition. A paralegal is a person qualified through various combinations of education, training, or work experience who is employed or engaged by a lawyer, law firm, government agency, or other entity in the capacity or function which involves the performance under the ultimate direction and supervision of a licensed attorney of specifically delegated substantive legal work. This is language you'll hear again and again and again in this course, which for the most part requires a sufficient knowledge of legal principles and procedures that, absent such a person, an attorney would be required to perform the task. We have here, attorneys are encouraged to promote paralegal attendance at continuing legal education. In hiring paralegals and determining whether they possess the requisite education, attorneys are encouraged to consider the following. This is that certification by NALA. This is the pay certification by the NFPA. And looking for these types of qualifications. Here's some definition about substantive legal work. Substantive legal work includes, but is not limited to, the following: conducting client interviews and maintaining general contact with the client, locating and interviewing witnesses, conducting investigations and statistical and documentary research, drafting documents, correspondence, and pleadings, summarizing depositions, interrogatories, and testimony, and attending executions of wills, real estate closings, depositions, court administrative hearings, and trials with an attorney. Substantive work does not include clerical or administrative work. We have here, and a paralegal is prohibited from engaging in practice law, providing legal advice, signing pleas, negotiating a settlement agreement, soliciting legal business on behalf of an attorney, setting a legal fee, accepting a case, or advertising or contracting with members of the general public for the performance of legal functions. So that kind of gives you an overview of that aspect. And so it doesn't say it as clearly as I had hoped, but the State Bar does encourage the use of paralegals. It is a way to provide legal services to people at a somewhat reduced cost, which can mean that more people have the ability to get access to legal services. So it is a good thing to do. It is something that is encouraged. Again, lower hourly rates. Paralegals typically charge significantly lower than attorneys, benefits clients, and helps more people get access to those services. Knowledge rules certainly encourage the use of paralegals. Obviously, it's an organization of paralegals. So, and also the ABA's models guidelines talk about when to use paralegals. And of course, states have guidelines such as the ones I just showed you. Talked about this in class, but just a little refresher. The scope of what paralegals do has broadened significantly since I started practicing in 1990. When I was practicing initially, let me draw a little. I might have said, if this is the universe of attorney-like work, and then I might have said back in 1990, this is the amount of work that paralegals could do. And now I would say, oops, wait a second, I didn't do a very good job there. Now I would probably say that this is the amount of work. There still is work that only an attorney can do, but but most work that attorneys do can be done by a paralegal. So there's been a dramatic increase of our understanding of what paralegals can do. Of course, it still requires that direct supervision by an attorney. Paralegals can perform most legal tasks as long as they're operating under the supervision of an attorney. But there is a line. There are some things only an attorney can do, so the paralegal has to be careful, and the attorney has to be careful that the paralegal does not engage in the unauthorized practice of law. So certainly paralegals can interview clients and witnesses, can investigate legal claims, can draft legal documents as long as they're going to be reviewed by the attorney before they go out beyond the law firm. And then this one can appear in a few closings and government hearings if it's permitted. That's not very common. There's relatively few. Now let me explain the word appear. In ordinary English, the word appear means to be visible, to be present. But in the legal context, to appear means to appear on the record, to be there in an official capacity. So paralegals routinely attend court hearings and trials, but even though they are present, even though they are working and billing their time, they are not considered to be making an appearance unless they are representing somebody. And so under those circumstances, they're there, but they're not there, kind of in a weird, twisted view of reality situation. So paralegals routinely go to closings and court hearings, but they can only appear at a limited number of those. And typically they're federal hearings when they do come up. Controversial issue is, should paralegals be licensed? Some think this would be a good thing. Some draw a comparison between a paralegal and a registered nurse. Well, a registered nurse has to be licensed before he or she can practice as a nurse. But a paralegal, there's nothing stopping anyone from calling himself or herself a paralegal. And so the feeling is, well, maybe that would increase the stature of this paraprofession, making it just a profession in that situation. Might increase pay, might increase the work responsibilities of paralegals. Others say, though, that there are many people who are paralegals who have risen through their work experience and perhaps may not have the credentials that more recent paralegals have. For example, they may not have graduated from a college or a community college, and they may have very specialized knowledge in their particular area, but they don't have a lot of generalized legal knowledge, and so they might not be able to pass a general legal type bar type test. So those are kind of the pros and the cons. California and Washington State have many paralegals who are not licensed, but they have established, California first and Washington more recently, a mechanism by which paralegals in those states can elect to have a license. And with this license, they are able to do some things independently of attorneys. This may be a trend. We might see many, many more states adopt this in the coming years. Just don't know what the future holds. Some organizations support licensing, for example, the NFPA. NALA supports voluntary licensing or voluntary certification rather than licensing. Now, I'll be honest with you, it would be wonderful if we lived in a world where people thought only of the benefit of clients and didn't think about the economics, but that would be fairly naive of us. Attorneys like the fact that they have a monopoly on the providing of legal services. If suddenly there was a group of professionals who didn't have to go to law school, didn't have to incur all that debt, who could do many of the jobs that attorneys do without having to be associated with an attorney, you can imagine that lawyers would not be too thrilled about that. And so whether it's a good idea or a bad idea, there are just some realities that we have to confront, that probably there is a limit to how far that can go. Paralegals, if you had one license for a paralegal, then that paralegal would have to show some competency in a broad range of subjects. That's the way the bar examination works. There is just one bar in a state, and so you have an attorney who is fully committed to practicing as a criminal defense attorney his whole career. He's taking the exact same bar that an attorney who is fully committed to doing tax work his entire career would do. They may deal with really not any of the same statutes at all, but they're passing the same test. Similarly, a doctor may know that he wants to be a brain surgeon. Another doctor knows that she wants to be an orthopedic doctor or an internist, we'll say. But they both have to understand how the body works, because systems are related to each other. If you know about the brain but no other part of the body, you're not going to be a very good brain surgeon. And sometimes your patients may present with a brain issue, but then they also have something that's nothing to do with the brain, and you need to at least know enough about those other areas to let them know if they need to seek medical assistance in those areas. And similarly, a lawyer needs to know enough about other areas to avoid doing something that's going to mess up the client in those areas, and also to know whether to refer his or her client to an attorney who specializes in those areas. But to ask paralegals to be journalists, to have that broad of a knowledge, is perhaps not the best use of resources. Imagine for a second that I'm a paralegal and I practice in the area of family law. I understand the Texas Family Code very, very well. I know how the courts work in the county in which I assist my attorney. But honestly, I have no knowledge of how securities laws work at all. and don't really want to know and wouldn't really have a reason that that would help my clients. If my clients have some kind of securities law issue, they're going to go to the attorney and see what the attorney thinks about that. So asking paralegals to become generalists would probably involve them learning some stuff that really wouldn't benefit them in their career and could set paralegals up for failure, because that person who knows family law like the back of her hand, she may fail the general test, and therefore then now she's in an awkward position. She's not a licensed paralegal. She can't do what she's really, really good at because she failed a test over subjects that really aren't related to what she does on a daily basis. In the next part of our presentation, we're going to talk about the Knowledge Code of Professional Ethics and Professional Responsibility. We're going to talk about the Texas Disciplinary Rules of Professional Conduct. And we're also going to talk about the Texas criminal law regarding the unauthorized practice of law. We'll start that in our next video. Let me stop here. We'll start on this slide 16, in our next video. Thank you for your attention. Have a wonderful day.